this next session, with which I am the chair for, is yeah. When this paper came in, so I was in contact with Bruce, actually, I think, and then he said, you know, Matsunaka Sensei should join us, and I couldn't be more delighted, yeah, to have them both talking about this issue of hostile takeovers in Japan. I know many of us in this room have some skin in the game in this debate. I do personally as well, which is why I used my authority to try to chair this session, because I'm so interested in it. And then when I saw the subtitle, right, that talked about the Australian Takeovers panel, I thought, come on, like I have no choice, yeah? if I don't put Jennifer on here to comment, it's like I will lose my job, yeah? So it's a wonderful match of true expertise, you know, with Bruce and Matsunaka Sensei on Japan, and then with Jennifer on Australia. You can't do any better than this. I won't take more time because we want to hear from them, so I hand it over, I guess, to Bruce to start it off for us. Yeah, thank you.
Great. Well, congratulations on this wonderful first meeting, which I'm very glad to be here. And thanks for Dan and the organizers for inviting us. And we're delighted to be here for several reasons. The first one is efficiency, because I think every person that we need comments from is probably in this room. So that's efficient. And second of all, we do have a reference to Australian law, which we're not experts on. And so if I had a choice of commentators from anywhere in the world, we would have ended up with Jennifer in any case. So very perfect for us. I should mention just briefly that we started on this something like 4 years ago, long gestation period, and my interest first came from my own personal experience as an independent director at a Japanese company. We unusually had a majority of independent directors, and we wanted to have a kind of US-style general takeover defense where the independent directors only would decide everything. And would that be accepted in Japan despite the trend against takeover defenses? And the answer was no, it was a very hard sell. So we started out with the idea it will be a case study of why an American-style defense is not accepted in Japan. But many things happened in the last few years that we'll be talking about. And as events occurred and the situation changed, we became more ambitious. Theoretically and comparatively, and also with an eye toward starting some discussion which would help reform in Japan. Okay, so particularly the last 2 points on here, we're going to try to work through and get through it in 20 minutes as close as we can. So because of what's been happening, I think there is a greater need for Japan to consider either completion or reform or both of its regime to regulate hostile takeovers. At the same time, I think there are new opportunities because many of the institutional players have increased their capabilities and may now be able to do more. So we have both new needs and I think new opportunities at the same time. So thinking about what would help a conversation towards reform, we have 3 goals. One is to revisit the theoretical frameworks that have been popular for takeover regulation. Second would be to apply this revised framework or updated framework to Japan to try to figure out where are the weak points, what is in the greatest need of reform, and who might be in a position to step up and do more in terms of institutional players. And finally, more specifically, we'd like to have as a reference point the Australian system and their takeovers panel, which we think could end up being a good point of reference for Japan. So this probably is not new to many of us, except for the Australia on the bottom. And by the way, II, no strong II on the right-hand side, that's institutional investors, kind of ran out of space. So in the leading article, I think, in this area, Armour, Jacobs, and Milhub from 2011, they talk about the subordinate lawmakers. The legislature does not normally deal with these kinds of takeover business law issues directly. And particularly, in both the UK and the US, there is one dominant subordinate lawmaker that both makes the rules and enforces them. And that's kind of the dichotomy, the US system versus the UK system. Their article also talks about Japan a bit. But so in the UK, traditionally very strong institutional investors. So they end up with with a takeover panel that has a code and enforces it. In the US, strong tradition of state courts making decisions on corporate law. So we end up with state courts, particularly in Delaware, both essentially making the rules and enforcing them. And Japan had neither one, institutional investors or courts. Certainly when cases first arose in the 2000s. So they had to do something. When cases arose, courts decided as best they could, even with incomplete rules. And there was a government agency, METI, the Ministry of Economy, Trade, and Industry, that tried to step in with non-binding rules to try to make that more complete. And we'll talk about Australia in a second here. So why Australia? It's arguably the only active takeover market after the US and the UK, although smaller. It also has some interesting features. We're particularly interested in the takeover panel. As everyone here knows, there are similar panels in Singapore and Hong Kong, but they are much closer to the UK panel. Australia has what we would call a more limited panel, limited compared to what? Well, limited compared to the UK panel. Not limited compared to the predecessor to the Takeovers panel in the 1990s, which had very limited powers and was not very active. And in addition, no dominant subordinate lawmaker dividing up the rulemaking and kind of enforcement function. This combination is judged to be a success, generally speaking. So we think it's an interesting example. I already mentioned some of the highlights. Separate out the rulemaker and the enforcer or adjudicator. And as kind of a corollary, one other thing that I think is very interesting. When we look at the US and the UK, we generally think of US has general rules applied by courts, legal rules. UK has more of a detailed code applied by a takeover panel, not legal rules, but business norms and best practices. So those are the two kind of models that we traditionally have in mind. And Australia does something very interesting. They have general principles under corporate law, but those are enforced by a specialized takeover panel. Not based on legal rules, but based primarily on business norms and best practices. We're not so caught up on principles versus rules, as we'll discuss in a minute. So if we separate out the subordinate lawmakers into rule makers and what we call umpires, people who are doing the enforcement, traditionally the literature has emphasized who is the rule maker. If a takeover panel in the UK is the rule maker, then they also do the enforcement. We think it's actually kind of the other way around. We think the umpire is most important because we need a neutral, independent, knowledgeable body that's going to make the final decision and be trusted in markets. And we're not so excited. We don't care as much about who makes the rules because general principles are okay. Hostile takeover cases are very fact-specific. It's impossible to mechanically apply any set of rules. If you look at the UK code right in the introduction, they say, we're not going to stick to the letter of the rules. We also want to enforce the spirit of the rules, even in a relatively detailed code. So we're not so excited about who's the rule maker. We're more concerned about who's doing the enforcement. Your turn?
Yep. Thank you for being this very efficient setting with the best commentator and the best chair. And the only cost for this setting is we had to keep confine Bruce into the 18-hour flight from New York to Singapore. And but I think it so I'll go into the presentation. At the beginning of 2000s, there were no strong institutional players. In Japan, institutional shareholders were not strong as now, and few independent directors were on board. Of course, the court couldn't be deemed as a strong institutional players as Delaware courts. Before the live door case, there were scarce rules on hostile takeovers, particularly on defensive measures. So the 2005 guidelines by METI tried to cope with this vacuum, and several cases followed. However, the authority of the boards and the bid decision maker, who is bid decision maker, still remained very unclear at this stage. And during this period, Japanese society as a whole was not welcoming hostile takeovers. Not only business leaders, but also a large part of the establishment didn't support the wave of hostile takeovers and shareholder activism. One impressive thing that happened during this period was that although some corporate law scholars born just after the World War II have been supporting the shareholder primacy, especially that they argued that the board shouldn't pick shareholders. Shareholders choose the board of directors. But all of them argued against actual hostile takeovers. So that was very impressive. Of course, the younger generation reacted very differently. But this was a situation in Japan in this period. So since then, many critical factors have changed. Many things are on this slide, but the most significant changes concern the shareholding structure. Cross-shareholdings have further eroded, and the institutional shareholders, especially foreign ones, have increased in number and also in power. The changes in shareholding structure affected other aspects of corporate governance, such as decreasing pre-bid defenses like Bruce experienced in his company, and increasing IDs. Likewise, Bruce was one of the independent directors in ECGI, and increasing shareholder activism. Consistent with the changes in corporate governance structure recently, a new wave of hostile takeover emerged, especially since 2019. And since 2021, there have been several cases in courts. These cases mainly focused on whether and when takeover defenses are permissible. Now, the cases clarified that if a board solely activates defensive measures, the court will strictly review, and it generally award an injunction. So it's very strict for board activated defensive measures. In contrast, if a shareholder meeting approves activation, even after the board makes decision to activate it, the court generally will not award an injunction. However, of course, there is some limit, even if a shareholder approves it, and it was set out by the Mitsubishi case. Although we have all these cases, since courts have ruled only on issues related directly to the particular disputes, directors' overall duties in hostile bid situations still remain unclear. So under these circumstances, METI set out new guidelines in 2023. The guidelines do not focus narrowly on hostile takeover and defensive measure issues, but rather tries to set broad standards of conduct on M&A. Just to mention important points, the new guidelines tighten acceptable circumstances for defensive measures. They further emphasize that shareholders' intent, which backs up the recent case law. In addition, the guidelines set the desirable conduct of the board when receiving an unsolicited offer. So it says that you can't reject unsolicited offers simply because it's unsolicited. So you have to consider it sincerely if the offer is made bona fide. Hard law has also been renewed, but to a lesser extent compared to soft law. The Financial Service Agency reviewed regulations on larger purchases and tender offers, but only proposed minor gap-filling changes for now. I think it's under deliberation at the Diet now. So I turn it on to.
Okay, I'm up again.
Yep,
This is really like a tag team. So I was a bit remiss. I should have mentioned when I handed over to Manabu, we spend a fair amount of time in the paper going through these recent changes in Japanese corporate governance that affect or are related to hostile takeovers. And the reason is we're trying to make a kind of relative judgment. If we're rethinking the theoretical framework and looking for new roles, stronger roles for institutional players, we need to think about what the changes are and who's gotten stronger, who's gotten greater capacity or capability to play a more important role. So when we think about applying the revised framework to Japan, we have to make judgments about that. And in our judgment, as Manabu mentioned briefly, it's really the shareholders whose power has increased most substantially over the last, I don't know, let's say 6-7 years, perhaps, meaning primarily institutional investors and also shareholder activists. Particularly since, I would say, starting around 2017 with the amendment to the Stewardship Code that required disclosure of individual votes by institutional investors. They've redone all their proxy voting guidelines. They've redone their procedures. They no longer deviate much from what those strengthened guidelines are. As a result, they now present a credible threat to Japanese companies, that if you violate a major provision of our guidelines, we will not vote for your directors when it comes time to elect your directors. And that has in fact occurred quite regularly. On the other hand, the courts have not changed much. Court-based system probably relies on independent directors. The number of independent directors has grown substantially since the Corporate Governance Code in 2015. Still a very small number of Japanese companies have a majority of independent directors. Even so, if you have 3 or 4 or some meaningful number, the problem is their function is still not well defined or developed. From personal experience, I can report that Japanese institutional investors don't trust independent directors at Japanese companies to be truly independent. It's a hard sell still. I don't think the guidelines call for independent committees to evaluate hostile bids. Courts give no deference that I can see to the decisions of those independent committees. So relatively speaking, we think the shareholders are stronger and can do more. And the other team in the equation, independent directors in courts, have not advanced significantly. Okay, so we really care about the umpire. So our other recommendations we don't feel quite as strongly about. But for the rulemaker, we think the new MEDI guidelines are okay. As I mentioned before, rules have to be principles. I don't think we need a detailed code in order to have a takeover panel. It's hard for a new player to make up a new principles or code. So it's not the only way to go, but if the MEDI guidelines are the easiest way to go, that's fine with us. As for the bid decision maker, in the absence of a UK-style mandatory bid rule, I think you're almost inevitably going to encounter some issue with defenses proposed by the board, and that's okay with us. Probably we prefer the second option of the board may propose defensive measures, but essentially requiring shareholder approval. We hope that maybe that will encourage independent directors to play a larger role. And then the recommendation we really care about is an Australian-style panel, which we think could be a significant improvement in having a mechanism that hopefully would be seen as neutral, independent, and expert for resolving hostile bid disputes. Okay, and now Manabu's going to give us the bad news about our proposal.
Okay, of course, there's some issues. If we are to adopt the new system based on the Australian system, first, where's neutral experts who could serve on the panel? In this regard, I want to emphasize that there's a substantial trade-off between independence and experience or expertise in Japan. This was we can find this kind of thing in the recent phenomenon because in the committee, as for the committee members of the 2023 guidelines, it was the structure of the comprise of the committee member was criticized by the English papers on being very biased toward target companies. And the critics itself was somewhat biased, but we cannot deny that all of the, most of the, not all, most of the lawyers, practitioners from the big law office was actually having experiences defending, not buying, purchasing the farm. So in this regard, there is a trade-off because they are actually very good and excellent lawyers, but they are all on the target side. The second issue is a relationship between the new panel and the courts. It would be a very big challenge for the Japanese legal system to bypass a court review formally, but maybe we can expect the courts to defer substantially to the panel's decision when making judgment. Japanese judges may consider this sort of things. And as a conclusion, this is our takeaways. First, Japanese regulatory system for hostile takeover remains incomplete, and especially for about the umpire, as Bruce pointed out. And I want to add that as for rule maker, I want to add that as for umpire, our suggestion is to make a system based on the Australian system. But maybe you support this or not. But anyway, our main takeaway is that we should divide rule maker role with and umpire role. It can be separate organization playing these two roles. And in Japan, the role of independent directors have increased much more compared to independent directors and courts. So in our opinion, an Australian-style limited takeover panel is a very good point of reference for Japan to achieve credibility in the regulation of takeovers through a neutral expert, independent, and predictable umpire. The problem is, who is that? Thank you very much.
Well, let me steal one more minute to add on to the conclusion a little bit. The tag team is in. So we don't like the idea that the U.S. and the U.K. are the two poles and we have to sort of choose between them. Not that anyone's actually said that. We don't like that, but we're hoping for a more flexible, nuanced system. But if you forced us to categorize things in terms of the US versus the UK, then I suppose I would say the current Japanese system is kind of US light. It's a mixture of the US and the UK, but at the end of the day, the courts decide. Even though the courts are not really, and this is not a criticism of Japanese courts. What court system outside the US could fulfill the role of the Delaware Chancery Court? I don't think there's any. not in Japan in any case. Independent directors also not strong enough. So it's a little unusual, strange, that we have a kind of a US-like system. So in a certain sense, what we're advocating is Japan should migrate over to a UK-like system. Not as strong a takeover panel as the UK does. So back in the 2000s, in the very early goings, a lot of people thought that Japan would prefer a UK-type system. Ex ante, not ex post, not dependent on courts and laws, but focus more on business practices. And my former colleague, Zen Shishido, says we didn't do that. Japan didn't have a takeover panel because institutional investors were too weak at the time. And there was no one who was in a position to represent all the interests in a way that would be perceived as neutral and fair. So relying on the courts, cases actually arose, you had to do something, but relying on the courts was the second best choice. But in our view, shareholders have improved enough so that maybe Japan no longer has to settle for second best choice. Maybe we could reconsider and get closer to a panel type system, which we think might end up being better. Thank you.
Thank you very much.
Japan is such an interesting case study when it comes to takeovers because we sort of see this shift. Thank you. We see this shift between the idea of encouraging foreign investment and economic protectionism. So we see it, for example, after 2008, a year after the Bulldog case that is discussed in the paper, we see this idea that Fortress Japan is back. We are back into this economic protectionism. And then even in the 1990s, as cross-shareholdings are unraveling in Japan, we see the Japanese business community suddenly think, oh, we might adopt US-style or Japanese-style version of US poison pills to, again, bring back that Fortress Japan type analysis. And so we see this in the paper. We see this shift from the 2008 global financial crisis, Fortress Japan, to this apparent economic dynamo that we have happening now in Japan. And that is such an interesting aspect of the paper. Now, the paper goes from documenting this shift to then describing what some of the deficiencies, and I liked the idea, that you had, Manabu, about, the vacuum in relation to Japanese takeover law now that we are seeing these economic changes. And so the paper describes the deficiencies and problems that are occurring as this shift occurs, but then looks for solutions. And of course, the heartwarming, let's look to Australia. So I'm going to divide my comments up into those two parts of the paper, say a few things about the Japanese description of the change, from Fortress Japan to economic dynamo, and then I'm going to say a few things about idiosyncratic aspects of the Australian Takeovers panel. So a strong message that comes through in this paper is the idea that community attitudes to hostile takeovers has changed in Japan, and that they are now seen not so much as swarms of locusts, etc., but they're now seen as effective accountability and disciplinary techniques in Japan. And that's a huge cultural change from late 1980s, where, the legendary US activist T. Boone Pickens met his match and famously had his fingers burnt when he tried to take over the Japanese manufacturing company, Koito. And he went away back to America with his tail between his legs. It's also a big cultural shift from what I described in the 1990s with the unravelling of the cross-shareholding, but the introduction of defensive tactics. And that took me to a comment by a US corporate governance expert, Robert Monks, which I found rather fascinating. And he said this, he said, in countries like Japan, and nobody is like Japan, there are always two games being played. The appearance of shareholder activism, which Japan Inc. considers to be important to its international image, and the reality, which is the ultimate commitment of government to defend national interests. And that is a really fascinating comment, because it runs counter to my last slide, which says there is this, sliding scale where sometimes, we're into protectionism and sometimes we're into opening up. Robert Monks is saying both are playing out at the same time in Japan, and that is very interesting from my perspective. And so I wondered to what extent the changes that this paper brings up are genuine, and to what extent they're reflections of Robert Monks, that we're seeing two games being played, and they're subtle and they're on top of one another. So, things that made me think maybe it's the two-game approach that's going on in Japan at the moment. The idea that Manabu mentioned, that most of the lawyers in Japan are still acting for corporate management in defensive roles. Now, that's changed in Australia as institutional investors have become more powerful. We now have groups of lawyers that are, going where the money is and going where the power is. But it's interesting that it's still defensive in Japan in terms of what lawyers are doing. But on the other hand, maybe it is genuine, because we're told in the paper that Japan has the second largest number of activist campaigns outside the United States. And on page 44, the authors say that Japanese trusts, which used to be trustworthy in terms of voting with management, can no longer be regarded as such, that they are breaking with management. And the paper says that one of the drivers for this is amendments to the Stewardship Code requiring disclosure of individual votes by institutional investors. But that kind of gives more power to stewardship codes than I'm used to thinking about. And so I do wonder whether there are other possible drivers, what's happening with proxy advisors, what's happening between, in terms of coordination between institutions themselves, etc. And are they collaborating with foreign investors? I was also fascinated in the paper by the METI 2023 guidelines, which are aimed at increasing desirable acquisitions. Well, boy, is that in the eye of the beholder. What is a desirable acquisition and what is an undesirable acquisition? And it made me think about how a number of regulators around the world, including my own, the Australian Securities and Investments Commission, have been trying to thread the needle in that way in relation to acting in concert, of when we want institutional investors to get together to improve corporate governance, and then when it tips over to, oh no, we're going to, it's all illegal because it's acting in concert. And that's, of course, something that Umakanth and Dan have been writing about recently. So the paper ends the Japanese section by saying we have some real problems in Japan with these changes that have been occurring. And what are those problems? They say, firstly, that in contrast to the Delaware courts, there is lack of judicial expertise and inconsistency in the judgments. And secondly, they say there is ambiguity under Japanese takeover law in terms of who are the ultimate decision makers. Is it the board, the sort of paternalistic US approach that the board gets to protect the shareholders, or is it the shareholders who are able to make decisions themselves? So those are the two problems they want to address, and they look to Australia to address those problems. So let me just talk briefly about the Australian position. So they focus on the Australian Takeovers panel as a regulatory model because they see it as an intermediate between UK and US. And I think at one stage in your paper, you say, oh, the UK and the US are both path dependent. Well, let me tell you, the Australian model is super path dependent as well, and quite idiosyncratic. So just in terms of, idiosyncrasy, the origins of the Australian Takeovers panel. There was a very influential paper that was brought out, prior to the introduction of the rejigged and the tweaked panel. And that paper was by It was by Justice Kim Santo and George Williams, and it was entitled Taking the Legalism Out of Takeovers. And they wanted to get rid of the law, you know, taking the legalism out of takeovers. And so that was what the Australian Takeovers Panel was designed to address. That's a very different problem to the problems that you've described in the Japanese context. Now, why was it a problem in Australia? It was because up until that point, when we had that weak first version of the Takeovers Panel, and it was very weak, it decided 4 matters in over a decade. And once the panel was made more muscular in the way that the paper describes, it took on over 148 decisions in the next 5 years, like a massive escalation in the number of matters. But what was going wrong in the earlier weak version of the Australian Takeovers Panel predecessor was it was all being played out in the courts, and the courts were overloaded, and it was being used as a takeover defence, that if you could get your matter into court, you could slow down the takeover, and foreign activists or foreign, people who wanted to take over the Australian company would just end up saying, it's all too slow, we can't get there. And so that was why it was taken away from the courts, to free up the courts to do other matters and to try to get this much faster, more efficient mechanism for deciding takeover disputes. I remember when it was first coming in, let's have a takeovers panel instead of the courts, it was very much based on the UK, and so I found your, Appendix A really fascinating, of just listing all the differences that ultimately came about. 1 minute, yeah, we're just going to power through here. And a lot of people said it won't work because, the English code is effective because everyone goes to the same clubs and you'll be shamed if the Takeovers Panel doesn't like you. And they said, in Australia, you're all convicts. You like being, it's going to be a badge of honour if you breach the Takeovers Panel. So, so there was a lot of pessimism about whether it would work, and it's worked brilliantly. But let me just very quickly tell you about some changes. I'm going to shift down. I'm not going to tell you, I'll tell you the structural suggestion and a query over coffee or lunch. But what I want to talk to you about in the last couple of minutes, or last minute, is the different trajectories of the Japanese and Australian capital markets and how that is changing what the Takeovers Panel does. Now, you say at one point, the Takeovers Panel is very successful, and it is. The Takeovers Panel has great buy-in by the Australian business community, and it does. But one of the things you use to support that is the idea that the government is thinking of expanding the Takeovers Panel remit to schemes of arrangement. I don't think that's the message coming out of that. No hostile activity in the public market is being undertaken in Australia by takeovers at the moment. It is all being undertaken by schemes of arrangement. And the takeover market, the public takeover market is dead in Australia. And that is a recognition that it has morphed into schemes of arrangement. And so that is quite important, that schemes of arrangement are now so dominant, and that the private capital market is much bigger. And that has resulted in a change in the role of the panel. It's now mainly disclosure issues, but it's getting more interventionist. So, so I'm going to finish there, but that is quite a different trajectory to the one that you're describing in the Japanese capital market that's occurring in Australia, and it is interesting how it is shifting the role of the panel. So thank you.
Thank you very much. So now I can collect questions. Yeah. I guess we'll start with Gen.
Thank you so much, Bruce and Manabu, for this wonderful presentation. And also enjoy the comments by Jennifer as always. So I have maybe 2 comments for your proposal. So you mentioned that the current Japanese situation, like having the court as an umpire, is the second best. Maybe it was the case maybe 10 years ago when we just had Blue Dog Source case, but I wonder whether it is still the case today after several cases came up a few years ago. And now we have stronger institutional shareholders, and shareholder structure have been changed a lot. And now independent directors, top market have like one third must be independent. And their decisions are respected not in the hostile takeover case, but in like all other M&As. And when there's a contested bid, their like special committees opinion is well respected. So I think it's a few more steps to maybe like full U.S. style, and I guess it's also we are just few steps to the Revlon duty in Japan. And I would say that judges are slightly more educated than in the past. There were a few very conservative judges in the past saying that funds are bad because they try to make money. But I think they all retired, and now the younger generations are more, reasonable. So in that sense, well, I do not find much trouble in having this. And also, we have now a clear rule that shareholders are other, decision makers for bids, that you mentioned. And courts decide on like exceptional cases. Mitsubishi was one, and the Tokyo Kikai was another one who tried to solve the issues of exceptional cases where they are coercive in-market purchase. And we are also about to change our mandatory takeover bid rules. So putting this all together, and we don't have any panels in Japan yet. So I wonder whether it's better to revisit the situation as it is, or try to introduce something very new that we don't know who's going to be on the panel. So and also you mentioned that panels would be more neutral, but I think you should be elaborate more on what you mean by neutral. So yeah, of course there are people who work for the target side and who work for the bidders. And I want to consider myself as neutral, but I'm not sure whether those working for the target side consider I am a neutral person. But so if it's like whether you like tend to take side for like pro shareholder or pro management, maybe no one is neutral actually, but you can be neutral on like individual cases. So I just wondered what you mean by neutral, and I think that will give more persuasiveness to your discussion.
Okay, Bruce has lobbied me to just take 2 questions and then give them an answer. So Shishiro Sensei. Yeah.
Thank you very much. It's a fascinating panel of all of you 4. And it is a very interesting phenomenon. I see that the 2 prominent U.S. corporate law and Japanese law professors, Bruce Aronson and my co-author of the poison pill paper, Curtis Milhaupt, both raised seriously that Japan, why not take UK system, but take US system, right? And one of the most famous corporate law professor in Australia, Jennifer Hill, expressed the doubt of the Australian takeover panel system. So everybody's in the world, the experts, are skeptical about the takeover system in their own nation, right? It's quite interesting, right? And this is not logical question or comments, but something like a comment from the feasibility. And I echoed with the opinion by Gen, and actually in early 2000, in the wake of Japanese shareholder activism and some hostile takeover attempts, I proposed that the almost same type of system, takeover panel, UK takeover panel system in Japan. why not? To the maybe most Japanese people know that the famous METI officer who have led the M&A and the corporate governance reforms, and his answer was, in one word, not feasible. How can we develop the panel every Japanese can trust and consider it, say, neutral? And also another point is, well, my question is, which is more quick to fix Japanese takeover system? Whether to try to find a very trustworthy panelists for the takeover panel and organizing such a system and persuade Japanese people that is the most trustworthy organization to as a final judge, or develop or refine the current system of a Japanese court and strengthen the independent director system, and as again said, slowly but gradually improve. And one more important point. In Japan, or Japanese really trust Japanese court, right? Interesting. You know, that is reflected by the fact the contract, B2B contract in Japan almost never ever include arbitration clause. That's opposite to the US-UK UK contracts. I asked many practicing lawyers in Japan, why? Because we all trust Japanese court. So it's hard to build up the more trustworthy decision maker other than the court in Japan. And so, well, it's kind of my observation as a Japanese. Thank you.
So yeah, two wonderful comments. I'll give Bruce. We have 4 minutes, but
Really?
we can extend a tiny bit, I think.
For Japanese situations, I agree with Ken that court can be trusted much more than it used to be. Judges are getting more and more experienced and expertise. And as Shishido Sensei pointed out, the court are trusted in Japanese society in general, partly because we don't have any jury system. But anyway, court is good in the sense of independence, and we agree with that. I think we have included that in our paper, right? So it's not broken in that sense, but there's a limit stemming from our, there is an institutional limit. For example, it's very difficult to make case on whether the board of the target should further consider a particular unsolicited offer or not. Or it's also very difficult in Japan to make a target to cancel a pre-bid defensive tactics. So there's this kind of institutional limit for courts, and interestingly, this relates to the role as a rule maker rather than umpire, solely umpire. So, as to the more fundamental point about which is feasible, it's very difficult to create a new good system, and maybe it's not feasible. It's simply realistic to improve the current system. But I think this applies to all the jurisdictions, and this is why there's very strong past dependence in all the jurisdictions concerning hostile takeovers. So, Bruce.
Okay. I think I'm going to mix up the questions and the answers, but I'll get to both of them. First of all, thank Jennifer for her comments. We were not looking that closely at Australians' actual practice. I was aware that the panel was set up to avoid kind of tactical litigation and that the situations are different. But we assume that, as is typically true in any kind of transplant, that you look at the institution, it will look very different when if and when it ever entered the Japanese system, that they will do something with it that will make it fit. So Japanese trust courts, I think so. A lot of this discussion is when people from MEDI and FSA come to New York and try to persuade global investors that we're doing well and doing more and we're going to continue our reform. So my counter question would be, do non-Japanese people trust Japanese courts? I think that's a significant issue for people like MEDI today. So I'm not sure. Another, I think, area of this, at the bottom of the slide, we didn't get a chance to talk about it. One suggestion was, how about if, as a first step, we create a voluntary, non-exclusive takeover panel? And parties will have the choice whether to utilize the takeover panel to settle disputes or whether to go to court. And that was something that was thrown around actually when we presented at the Financial Services Agency, because they were very sensitive to the obstacles of creating a whole new system. But to go back to the Australia example, for a decade or so, they had a very weak system which didn't work well, but they tried it, and they learned from it, and they found out what the problems were, and they eventually decided to move on to something else that was stronger. And I don't know if that would happen in Japan or not, but I'm still not convinced that it's a waste of time. I think that would be something worth doing. So neutrality and independent directors, again, so that's a big issue. I would define neutrality as more a perception of neutrality by people, again, not just including Japanese investors, but global investors. And maybe they have too much memory of the 2000s cases, Bulldog Sauce and cases like that, where even if the district court does kind of okay when it's appealed, the higher up you get, the worse the decisions become, the less informed they become. I don't know if that's changed. Independent directors, I have to be careful not to rely too much on my own personal experience, but at least when it comes to hostile takeovers and defenses, boy, it was a hard sell. Independent directors will decide. For example, just to give one example, we claimed we would act like US independent directors. So if there's a really good bid, we'll take it seriously, and maybe we can use it as a tool to get time and information, and maybe even negotiate with the bidder. And Japanese institutional investors would look at us, and the reality is, there's no real world example of that happening in a Japanese company today. So we can say, oh, we're enlightened independent directors. I know all about the American system. We couldn't sell it. So, you know, you may be right, and I hope you're right. Nothing would please me more than to have independent directors in Japanese companies have their decisions more respected. And I think they are making gradual progress. But I don't see it as a full solution right now. Thank you.
So yeah, we have just 1 minute, so I'll collect questions. Abusing my prerogative as the chair, I'm just want to ask you one question about stewardship that sort of Jennifer had raised, and then I'll collect the other questions around, which is, as I suspect you know, Alan and Nakahigashi Sensei and I wrote this paper, Land of the Falling Poison Pill. Yeah, and in that paper, we suggested that stewardship was actually quite a important driver of the decrease in the poison pills. And I'm just wondering, because we did get pushback from people on this, and you seem to suggest that it was quite strong. So self-serving. I would like to hear more about your evidence because it bolsters our case. But especially Bruce, you with your actual experience, right? That's of great interest to me. I go to Wei, and then I'll go to Alan. Yeah.
I have a quick question, Bruce, to your answer to the previous question, actually. You mentioned, sounds like you suggest you can have a optional panel. You choose to go to panel, go to court. I wonder how can this happen? Because we are talking about hostile takeover and defense. It's a very confrontational situation. How can the party agrees to go to one panel, one platform instead of another? It's not like the regular arbitration case. So that's my question.
So I'm just very stimulated by the discussion of what kind of institution might actually work. So I just thought instead, and it's always fun, right, as academics to propose new institutions inspired by foreign models. I think this is how we kind of satisfy ourselves that we're doing good work. But I was just wondering, on a practical perspective, for the Japanese, right, who are sometimes quite suspicious and with good reason of foreign ideas, why not work with what they already have? Okay, so you pointed out, I think it's an excellent point, that Japanese businesses trust Japanese courts, but maybe foreign businesses not so much. But Japanese businesses also engage in mediation. And mediation has a bit less of that, I think, forceful nature to it. So perhaps an interim solution for your voluntary panel could take the form of mediation, perhaps by first introducing maybe retired judges from the 8th Civil Division to lend some imprimatur, quasi-state imprimatur. Because I know sitting judges may find it difficult to participate in this kind of mediation practice. But once this thing has sort of gotten underway, perhaps you could even set up like whatever you want to call it. Maybe you're going to change the name a little bit. Maybe set up as a special version of the 8th Civil Division proceedings with sitting judges, but also other perceived to be neutral parties who have built up some kind of reputation and track record through this voluntary mediation thing. An alternative, which is I think which is very good for someone like you, Bruce, might be to try and join in, like say, the 8th Civil Division proceedings as a senmonyin. Because there is technically the senmonyin system, which is a bit underutilized under Japanese civil procedure. But if the question, right, I think if the issue for foreign parties is the perceived lack of expertise of the Japanese courts even today, then let's stack it with experts. But to keep it within a framework that the Japanese might still be comfortable with. Thank you.
So Jennifer has one point, and then Bruce, I'll give you 60 seconds, and we'll wrap it up.
So just on that optional, court or panel, one thing that was interesting about the structural shift in Australia to a panel was it changed the substantive law. In the courts, it was directors' duties, which was focused on intention of the directors. Once it went to the panel, it was frustrating action, the effect of the acts. So that would really complicate if you could choose between the courts or the panel.
Good luck.
So first, stewardship. Manabu has not yet gathered the data, but it's there. So starting in 2017, right when there's a new requirement to disclose individual proxy voting, in the company I was at, the votes in favor of the CEO declined dramatically at that meeting when I first joined the company. And that's not just one company. There are industry-wide data, which I think will clearly show that 2017 is a breakpoint, and that overall institutional investors start voting no against election of directors when their strengthened guidelines are violated. And so we will have both overall data, and in a little footnote, I have a case study from my company because I have data on that. So no, I believe that's true. Also, I don't know, I hate to say because it's a Japanese organization, but when you deal with institutional investors, now we have these tougher proxy voting guidelines and we have to disclose every vote. So it used to be, including my company, it used to be, well, this doesn't exactly follow the guideline, but overall we think you're a really good company. And by the way, we're supposed to make overall decisions. We're not supposed to be just checking the box and be bound to every specific thing on our voting proxy guideline. But the reality is they start checking the box. Because if the person at the mid-level wants to do something different, now there's new procedures. He has to go to a new committee, which might include outsiders. He has to make an application. And one of them told me, well, you know, I'm just a salary man. That's a lot of work to get all this cleared for your company. That's a little too much. I didn't quite say it in those words. I'm rephrasing. So that's all I have to say about stewardship. I firmly believe that it was significant. What else? Voluntary. Yeah, that's so we should confess. We were mainly interested in updating and rethinking the theoretical framework in a way that might aid reform. We did have a presentation at the Financial Services Agency and discussed some of the obstacles, and that's included, at least, but that's all preliminary. It would be beyond the scope of our paper to get into great detail about very specific obstacles and strategies to implement this. Our paper's already longer than I wanted it to be, and I think that's kind of the next phase, where if there's interest, we can work together with the proper parties to try to help out on that. So that we don't have good answers at this phase to that, although I think both of Alan's suggestions are very interesting and we're thinking about.
So thank you very much. A wonderful panel, a terrible chair. Yeah, I was too interested in what you're saying, so I can't cut you off because I want to hear so much more. But with that, let's thank the group for a terrific paper, terrific commentator, and we move on now to another exciting panel. Thank you.